Selecting the proper trust jurisdiction matters for so many different reasons in the trust planning process. But probably the most compelling area and the most measurable area in this planning process, where you can quantify what happens if you, or quantify and qualify what happens if you make the wrong decision, is in the area of taxation of trusts. As we all know, each state has a different tax rate at the state level. It's an income tax rate that's applied not only to individuals, but also it applies to trusts. California is one of the highest at over 13%. Pennsylvania is not as onerous, but still there at about 3%. New Jersey is about 7%. And each of these states apply those taxes to undistributed income inside a trust. But what has developed over the last 5 or 8 years is a very fascinating concept around whether a state has the legal authority to tax a trust that is actually domiciled in a state other than the home state, but has beneficiaries or settlers that are actually in the home state. So for example, a settler that sets up a trust in South Dakota or Delaware, were states, those are 2 states that do not tax at the trust level, but still lives in Pennsylvania or has beneficiaries in Pennsylvania, the presumption is, and has been for years, that Pennsylvania is allowed to tax the undistributed income on that trust at a little over 3%. What's fascinating is that case law, not only in Pennsylvania at the appellate level, but across the country, is beginning to indicate that that is unconstitutional. So why is that important to the planner? A state like Pennsylvania says that it's unconstitutional for a state like Pennsylvania to tax a properly situated and set as trust in another jurisdiction, thereby removing the 3% tax on undistributed income. That trend is seen in New Jersey in some recent case law, and just recently out of North Carolina. That is an extremely compelling development across the country, which indicates that trust jurisdiction really matters here. And you can save a tremendous amount of money on taxation relative to undistributed income. Now, it's important to make a distinction. We're talking about income that is generated within the trust that is non-sourced to that state. So for example, investment assets that are held at custodians around the country, that the courts have looked at and said, look, the income that is distributed or undistributed that remains in the trust for liquid assets can't be taxed. And that's what Pennsylvania said, that's what New Jersey is saying, and that is what North Carolina has recently said. And so far, private letter rulings have supported that approach for California trusts as well. So in the context of tax planning, and particularly trust planning, but tax planning, choosing the right jurisdiction becomes vitally important because it equates to actual real savings that can be measured. And if the practitioner or the planner isn't aware of the development in the case law around the country and just decides to place a trust in Pennsylvania or decides to leave a trust in New Jersey or California particularly, it could cost the trust a lot of money in taxation that could have been avoided just by simply selecting a more favorable and progressive trust jurisdiction. For more information about how this taxation is applied to various trusts around the country, please feel free to contact Bridgeford Trust Company or check our website. There is a chart there that goes state by state that explains specifically the tax rates in each state, which makes the point even more compelling just how important it is to select a trust jurisdiction that makes sense and that does not tax trusts at the state level. We hope to hear from you soon and happy to answer any questions and be part of the wealth planning process.